Hello, my name is Mohammed Sagir and my Hertfordshire ID is 230157008. In this video, I will address the issue in contract between Aminas Textile Limited, managed by Javaid, and Nationwide Fabric Limited. I will focus on the effective and incomplete deliveries, the nature of several contracts, payment obligations, key provision of Sales of Goods Act 1979, and relevant case law. After that, I will advise Javed on his legal right and remedies. The SGA 1979 grants a contract for the sales of goods, requiring that goods correspond to their description or the satisfactory quality and delivered according to agreed term. This legislation for protect consumer by ensuring that the product they purchase meet certain standard and expectations. The act also provides remedies for the buyer in cases where their conditions are not met, allowing them to seek a refund, replacement, or repairs. The contract can be considered as a several contract because the deliveries were to be made in three installments. Under such agreement, each installment is treated as a separate performance, allowing Javaid to elevate each delivery independently for complaints. The case of Nepal. On 20th September, NFL Limited delivered 5 meter of mulberry silk and 10 meter of white cotton and 10 meter of black cotton instead of agreed 10 meter of mulberry silk and 20 meter of white cotton. They constitute a breach of Section 13 of the Sales of Good Act 1979, which state that goods must correspond with their description as confirmed in Across versus Nansen 1933, where even a minor deviation for the contract description were deemed a breach. Additionally, Section 14, subsection 2 of SGA required goods to be satisfactory quantity and substitution of black cotton for a white cotton affect the quality and instead use of goods as seen in Grant versus Australian 1936, where defective goods fail to meet the buyer's expectation. Finally, Section 30, subsection 1 state where quantity delivered are less than agreed, which applied here due to the shortfall in silk and cotton. Javaid may reject the installment or accept the goods and claim damages for the deficiency. On 23rd September, NF Limited delivered 3 meter of mulberry silk and 10 meter of white cotton, falling short by 7 meter of silk and 10 meter of white cotton. This breaches Section 14 subsection 2 of the SGA, which requires goods to be satisfactory quantity if the quantity delivered is less than the agreed. Furthermore, Section 29 requires goods to be delivered in manner that provides the buyer with a reasonable opportunity to examine them. The principle in case of Remore and Launder 1921 confirm Javaid the right to reject the installment or accept the delivered goods and claim the damage for shortfall. Javed seek to cancel the third installment due to constant breaches by NF Limited under Section 35 of the Sales of Good 1979. A buyer may reject goods within a reasonable time if they do not conform to the contract. Persistent non-conformance, such as short or incorrect deliveries, given the buyer ground to treat the contract as repudiated. If the breaches go to the root of argument, the case of Maple Folk Limited versus Universal Furniture Products 1934 support this, establishing that repeated breaches in installment delivery can significantly impair the value of the entire contract, justifying determination. Section 31, subsection 2 of SGA provides that if a defective deliveries in an installment contract substantially impair the value of a contract, the buyer can treat a contract as a repudiated. Thus, Javaid is entitled to reject the third installment and determinate the contract within reasonable time, safeguarding his right under the SGA. Under Section 28 of SGA, payment and delivery are concurrent condition, but in this case, both parties agree to pay after 1 week of delivery, since the goods were not delivered in the correct quantity and were substituted with the incorrect item. Javaid is not required to make a payment. Additionally, Section 29, subsection 6 implies that a buyer is obliged to pay the for goods that do not conform to contract. The case law of Smith line supports that the principle that a buyer is not obliged to pay for a goods that do not conform to contract. Javaid is not obliged to pay for non-conforming deliveries if he has rejected the goods. If Javaid has accepted the delivered less quantity of goods willingly, then he will have to pay the delivered goods on agreed rate and can seek correspondence under Section 51 SGA, which incorporate the remedies for a buyer in the seller failed to deliver the goods. It allowed the buyer to claim damages for non-delivery calculated based on the loss directly resulting from the breach. Otherwise, the has a right to reject all goods under Section 30, subsection 1, and seek compensation under Section 51. In conclusion, Javaid has several options under the Sales of Good Act 1979. He can choose to accept the delivered goods and claim compensation for shortfall and non-conforming items, ensuring he is reimbursed for any losses incurred. Alternatively, he can reject the defective deliveries entirely, determinate the contract under Section 31 due to the significant breaches, and refuse to accept the third installment. Both options safeguard Javed's legal right while allowing him to pursue remedies for the seller's failure to meet contractual obligations. Thank you so much.